Thank you very much. As you know, most of the attention in the Obamacare cases has been focused on the constitutionality of the individual mandate and whether that is constitutional under the Commerce Clause. And one of the arguments is, if Congress can force people to buy insurance under the Commerce Clause, what can it not do? That would, in theory, expand federal power to the point where, practically speaking, it could do anything it wants. Well, a very similar issue is presented when we talk about the Medicaid expansion, because that is done under a different clause of the Constitution, the taxing and spending power of the Constitution. And the question here also is whether Congress really has any limits at all. The federal government spends money by giving it to states, and it says to these states, if you want this money, you have to comply with our requirements. Well, the question then arises, what kind of conditions can the federal government put on the receipt of federal funds? In the most famous case on this is the South Dakota versus Dole case. That case, the federal government required the state of South Dakota to change its drinking age in exchange for receiving certain federal highway funds. And the state challenged that and said that that was unconstitutional and interfered with the state's authority as a sovereign to make these decisions for itself. And the U.S. Supreme Court, in a decision by Justice Rehnquist, said that this was still constitutional, but there might be cases where Congress was going too far. Well, of course, just as in the Takings Clause cases, we don't know what goes too far means. And since then, there's really been no development in the case law on this issue. And keep in mind that in that case, in Dole, we were talking about 5%, I believe it was, of the federal highway funds. I believe the total amount of money involved in Dole was something like $4.5 million. Now we are talking about a tremendous amount of money, as we saw. In fact, Medicaid funding to states is usually, federal health care funding in general, is usually the largest single block of any state's budget. And the states are told that they must comply with the ACA's requirements or they lose all of the funding, not just the incremental increase that might be caused by the new requirements, but all of their funding. As you saw, the bill the new act requires states to expand eligibility, and then it requires people to sign up for health insurance, which they can do by signing up for Medicaid. So the states argue that the law basically forces people onto their Medicaid rolls. And since states will bear an increasing share of the costs for this over time, it basically forces the states to take over the care of these individuals. Now, the defense is, and the defense in Dole was, well, this is basically just a contract. States take the money, they agree to the strings attached to that money. If they don't like the conditions, they don't have to take the money. Well, that may maybe have been an argument in Dole, but it's hardly an argument here. After all, as I said, the states lose all of the funding if they reject these conditions, and it's worse even than that. They might lose funding for other federal programs if they reject these conditions. And the argument that we made in our amicus brief is that states actually can't opt out of Medicaid now. Under another federal statute, EMTALA, the Emergency Medical Treatment Act, it is a federal crime to transfer a patient from one hospital to another for an indigent patient for financial reasons. So there was an article in Reason magazine a few months ago about this, that if a state tried to say, you know what, we're opting out, we don't want to be part of this anymore, they would have to set up an alternative state-based system to take care of the indigent, and that would require them to transfer patients, which is a federal crime. So states are not actually able to opt out of the Medicaid system. The argument that we made in our amicus brief also, and that's hinted at by the states in their briefs, is the spending clause really should be limited to the enumerated powers in the Constitution. The spending clause should not be treated as an end run around the limitation on federal power in the Constitution. Right now, the federal government has certain powers listed in Article 1, Section 8 of the Constitution, and it can't, in theory, do anything beyond those limits. But they have been using the federal spending power to get around those limits and impose federal policy by inducement. And this inducement is, as I said, is in a tremendous amount of the state budget. And if a state did try to opt out, it would still have to send its tax money to Washington, D.C. to be spent on those states that still opted in, right? It's not like if a state says, you know what, we don't like these conditions, we're not going to take the money. It's not like their taxpayers are relieved of their burden to support those states that do opt into the system. They're still required to do that, which would mean that states would have to raise their taxes tremendously in order to overcompensate for the loss of funding. Now, the federal government's argument is, the Health and Human Services has always said they retain the authority to withhold Medicaid funding if you fail to comply, and the Medicaid Act was always made conditional that we could change the conditions required, and if you allow states to say we don't like the conditions that go along with this funding, that's basically allowing the states to dictate the use of federal dollars. Those are reasonable arguments, and the problem here is that there really is no case law. Where do we draw the line to say these conditions are too burdensome? Will the court want to get into that issue? Will the Supreme Court want to get into saying, well, some conditions are too extreme? Because if they do, you'll see a lot of lawsuits brought by states to invalidate conditions on federal funding, and the court will be forced to come up with some other test to apply to these conditions in such lawsuits. But the argument against that the states make in their brief is we have to draw the line somewhere. In 1936, in United States v. Butler, the court said, if in lieu of compulsory regulation, Congress could invoke the taxing and spending power to accomplish a forbidden end, then the spending power would become the instrument of total subversion of the government powers reserved to the states. That's clearly true. You can't say that it's a fair exchange when the highwayman says your money or your life. And the same thing is true of the federal government's relationship to the states. Federal government we already know from the coercion cases that the federal government can't force states to do certain things. New York versus United States said Congress can't just compel a state legislature to pass certain laws. Well, it also shouldn't be allowed to say, you have to give us your money, you have to give us federal income taxes and other taxes for us to spend as we will, and we'll give some of that back to you on the condition that you comply with our demands. And our demands, by the way, exceed our constitutionally authorized powers. That is an unreasonable way of interpreting the Constitution. How do I think the court's going to rule? It's hard to tell. This is, as I said, basically a blank slate. We have Butler from 1936, and we have the Dole case, and that's about it. No court, so far as I know, has ever enforced the spending clause as a shield against federal power. And I think that the justices will be skeptical of wading into this area. But I think that Dole makes it very clear that some things have to go too far. And when we're talking about this system that basically co-opts the states into branches of the federal government with regard to medical care, then you are talking about something that goes too far. Thank you.